I mean, what Michael has done is he's right on the case and abjectly wrong on the implications that he draws from it. If you go back, the question is how you draw inferences from single instances, and there are two questions to ask. One is the Brock-Jean decision correct within current patent law, and secondly, should we blow up the whole system? And I've always thought that the case was wrong under current patent law, and let me explain to you why. The 1911 decision that Learned Hand issued with respect to the isolation and purification of adrenaline was known to be an exception to the general rule that you cannot patent natural substances. And the reason he gave the patent rather than a process patent is he thought that, quote unquote, this was a whole new product and you were going to commercialize it in the sense that Scott talked about, buy and sell the adrenaline that you've managed to isolate. If these guys with the Brack patent wanted to take the gene and crystallize it and sell it, that would be just fine as far as I'm concerned. But they're trying to use the thing not as commercialization but in situ. And my view is the exception that Hand created for the natural substances doctrine doesn't apply to that case. So I think that when Daniel says this, he's right on the facts. But the thought that we are going to destroy the entire biotech decision, on which relies on the isolated and purified rule in order to correct one injustice, is a case of massive overkill when you have a relatively simple response. And this, in fact, leads me to the comments that I have to Michael, which is he puts up the graph, and Scott and I think, have the same reaction to it. Gee, that's exactly what we would have predicted. As you increase the uncertainty with respect to the underlying property rights, you would expect to see an increase in the amount of litigation that takes place. And so the question is not whether you have the correlation, but whether you have an explanation for it. He's correct also, I think, Michael, because it was a wonderful presentation, to sort of indicate that when you are starting to talk about mosaic patent cases, the software device with 10,000 things, you really do not want to have a system where you have to call back everything that's out in the market because there's one patent which may have been infringed given the difficulties of notice. But I think there are two things you want to do in response to this, both of which are worth a mention. One of the things is we have systematic underinvestment at this particular point in time in the public space. You put money into the patent system to file it, and Congress appropriates it somewhere else. The typical government failure is we don't expand infrastructure to deal with superstructure, and that's a straight political failure, and we're in Washington, the town of all political failures, so this should be no surprise to anybody. The second point, with respect to the question of why all this stuff happens, is I think in a different way. It's if you run a particular system in which you will not give a specific definition of rights, you're going to get the kind of residual confusion. And so what you need to do is to figure out how to handle the mosaic question. And this is what I would suggest, which is going back to the rules of injunctions that you had in physical cases. No injunction when you had to close something down took place instantaneously. There was always a grace period. And so the way in which you handle this is you don't get rid of injunctions or no injunctions. You simply have a temporal rule. You got this stuff in there. Everything that's been sold will give you a royalty, and it won't be very high because we know that the rates of substitution are very rapidly. We give you 6 months, and if you could fix it for future production, that's fine. Since most of these things, as Michael says, are easy fixes, right? And you can do it in that particular time for your production line, the value of that lawsuit is going to go way the world down. And so with the temporal remedy, you can have the best of both worlds. And this, I think, shows why Daniel's approach got it 180% backwards. If you understand systems of physical property, which most intellectual property lawyers tend not to do, you'd realize they're much more sophisticated and subtle, and they give you real guidance on the intellectual property side. If you don't understand those systems, then you'll just repeat the same kind of blunders that you could learn from some everywhere else. And my experience with most IP lawyers is they don't know property law, so they tend to treat intellectual property as a sui generis subject matter, which always leads them to wrong decisions. And if you want to talk about 9 people who know nothing about property law, I can tell you where to look.
And I guess I should start by just picking up the last conference we were at. We were having a discussion on Richard's last point here about the subtle treatment or crafting of injunctions in property cases. And remember, we talked about intervening rights with regard to reissue patents. Yes. So any patent law geeks out there who know about reissue patents know there's an intervening rights doctrine, which is something, I think, in the same spirit of what Richard was just talking about. And that's a sensible attitude that, you know, one problem we have is we've got to educate district court judges to use the tools and the discretion they already have and to use it in a sensible way. So that's something no one's talked about, but I think we probably all sense that that's right. But okay, so let me step back and talk about some of the comments from the Globetrotters. So first of all, one other comment Richard made. Richard tells some nice stories about difficulties with expectations damages. And some of the nice stories explain why those expectations damages are too small. When we talk about damages in the context of patent law, I think we tend to perceive lots of reasons why damages are too big. You know, starting with juries, maybe ending with juries, but you know, back to Marshall, Texas, if, you know, I've listened too much to those ICT people, I guess, but they seem to be telling me that damages are way too big. They're over-awarding. There are biases to over-award. Maybe those biases can be dealt with at the district court level, and there's been a lot of talk about gatekeeper functions of district court judges using Daubert rules, for example, to throw out some silly stories about how damages should be calculated. But at any rate, even though I believe that there are factors that systematically understate expectations damages, there are factors at play in the patent system that lead to overstatement of damages. Again, we got this big political economy divide. Pharma people have a very different attitude about this, and they see maybe there are different particular issues in the case of pharma. But with ICT, the real hazard, I think, is overstatement of damages, not understatement of damages. Both Richard and Scott observe that some, but I think they agree, not all the reforms that I support increase uncertainty. Some of the reforms I support decrease uncertainty, some of them increase uncertainty. I admit I'm not focused on uncertainty. When I talk about reform here, I'm focused on boundaries, getting the boundaries right. I have, in the book, lots of empirical argumentation that explains why the graph I posted is causal. And I want to share a little bit of that with you right now. And it would be unfair for me to ask those guys for any kind of empirical evidence that the uncertainty being created today is going to cause bad things. It might be true, their story is plausible, but there's no evidence for their story. There is lots of good evidence for my story. 1980s, the Federal Circuit arrived on the scene seeing that Japan was technologically very progressive. People were worried that we were falling behind. The mission of the Federal Circuit, according to Judge Markey, is let's strengthen patents. And they succeeded in doing that. They reduced the probability that a patent would be invalidated. And they strengthened damages available to successful patent plaintiffs. What happened in the 1980s, early 80s? Less invalidity, less uncertainty. What did that do to the rate of patent litigation? Had no impact. What did it do to patent value? Went up. That's good. So we had a change in the uncertainty in the system, but it had no impact on the amount of litigation that occurred. 1990s was different. The Federal Circuit had a different agenda that involved the cases Markman, lots of DOE cases, in re Brena, Allapat, State Street, cases involving continuations, continuing patents. These were the problematic Federal Circuit cases. They're the ones that made boundaries less clear, and that's what triggered the explosion of patent litigation, the imposition of costs on innovators. And reversing some of those, like State Street, for example, is not, in my mind, well, we don't know what's going to happen, but it's not clear that creates greater uncertainty, but it's going to cut out a class of invention that cannot really be propertized successfully through the patent system. And so that's a sort of policy that I think is certainly going to make for clearer boundaries. And remember, what I was emphasizing all along is that software is where the problems are. We've got to think about a way of delivering reforms that are going to benefit ICT without harming pharma. And I think we can do that. Pharma is very skeptical because that's the politics. They want no reforms, regardless of whether anything bad will happen to pharma. They're pushing against all sorts of reform because they don't see anything in it for them. They're not going to be harmed by it, but they're being cautious. And we can't let that determine the outcome of patent reform.